Thank you, Your Honor. May it please the Court. I'm Mckenzie Price, and I'm here today on behalf of defendant and appellant, Detective Whitney Walley of the South Haven Police Department, in this appeal of the District Court's denial of qualified immunity to Detective Walley on Mr. Lewis's sole remaining claim. That claim alleges an unlawful search and seizure of Stephen Lewis's cell phone contents by Detective Walley in violation of the Fourth Amendment. The District Court erred in denying qualified immunity on this claim, as the District Court relied solely on a broad, general proposition of law signed to the 2014 decision of Riley v. California for just the broad proposition that generally an officer must obtain a warrant prior to searching a cell phone instant to arrest. However, the issue is not whether Detective Walley was required to obtain a search warrant prior to looking at any contents of Stephen Lewis's phone, because she never had possession of Stephen Lewis's phone. It is undisputed that Detective Walley never had access to any of the large troves of personal information contained within Mr. Lewis's cell phone. It is undisputed that on November 19th, when Detective Walley received an email from an outside law enforcement agency containing a singular photograph, which had been previously represented by that outside agency as having been obtained through a valid search warrant on Mr. Lewis's phone, that at that time, Detective Walley did not have Mr. Lewis under arrest. She did not have custody of Mr. Lewis on November 19th. There is no question of a search instant to arrest of a cell phone. Rather, the question presented is whether a law enforcement officer who does not have possession of the cell phone, who never touched the cell phone, who never even had access to a digital reproduction or data replica of the cell phone, who never had access to the trove of personal information contained therein, who instead merely opened a singular email from an outside law enforcement agency after having been told that the sole attachment to that email was obtained through a valid search warrant on the cell phone with just one singular photograph of a Best Buy receipt attached to that email, whether that officer, whose conduct, as I've just described, was merely passive receipt of information, herself actually searched the cell phone contents under the Fourth Amendment. The answer to that question must be a no, and at a bare minimum.
Had she been told that there had been a warrant?
Yes, Your Honor. On the record, page 14, paragraph 27 of the complaint, Mr. Lewis has pled in his complaint unambiguously that, and I have the exact language here, he has pled unambiguously that on November 19th of 2020, Detective Walley followed up with Detective Witherspoon, who had called the day prior, and during that phone call, Detective Witherspoon, quote, informed me that during their investigation, he located several electronic items and completed a search warrant on Stephen Lewis's cell phone. Not only has this been unambiguously pled in the complaint, Mr. Lewis has stood by that allegation, notably in his opening brief in this appeal on page 8, Mr. Lewis stated, it is undisputed that before Detective Walley received the email, she had been told that the photo of the Best Buy receipt was obtained through Detective Witherspoon's investigation and completion of a search warrant. So at a bare minimum.
But there's nothing in the record other than that to indicate she had been told anything like that.
Well, Your Honor, we have the plaintiff's allegations in the complaint as well as the report that is attached as Exhibit 6, I believe, to the complaint. That should be at record page 41 through 43, showing that these are the sworn statements of Detective Walley as well as the sworn allegations of Mr. Lewis. But when it comes to the Washington County Sheriff's Department investigator / Detective Witherspoon's conduct is not before the court. So the question of whether or not he had actually obtained a search warrant on that day or whether he had acted properly pursuant to that warrant is not before the court. What is only before the court is the undisputed fact that Detective Walley had been told that the singular photo of the Best Buy receipt was obtained through a valid search warrant, and as this court knows under qualified immunity.
Assuming Witherspoon had tried to get a search warrant to go into this cell phone or mini computer, whatever it was, what was the reason that he needed to search that cell phone or that mini computer?
Well, Your Honor, when it comes to...
knowing full well that he could not obtain it except through a warrant.
Well, when it comes to Investigator Weatherspoon's conduct, Weatherspoon of the Washington County Sheriff's Department had arrested Stephen Lewis on November 13th on 2 counts of auto burglary and 1 count of credit card fraud. Now, the warrant that Detective Investigator Weatherspoon subsequently obtained is in the record and shows that due to the allegation and charges of credit card fraud, in addition to, and as I said, Investigator Weatherspoon's conduct is not before the court. However, Mr. Lewis did file a separate lawsuit against the Washington County Sheriff's Department, prosecutor, a very large slew of people. That is public record, and it's available on PACER. It was also pending at the same time before Judge Brown. That would be number 4:23-CB-187-DMB-DAS. But when it comes to Investigator Weatherspoon's conduct, he subsequently obtained that warrant, and through the public filings on the Washington County case, it can be seen that the reason he would have wished for a warrant to search the cell phone is when Stephen Lewis was arrested in Washington County on November 13th, there was an inventory search of his vehicle done, during which evidence of the credit card fraud was located. There were 2 iPad Pros located in the vehicle, but the receipts could not be found other than on Mr. Lewis's cell phone. But all of these facts that I've just described pertain to Investigator Weatherspoon. But when it comes to Detective Walley, in the qualified immunity analysis, what matters is not the 20/20 view of hindsight. All that matters is what the detective knew at the time of her challenged conduct. Here it is undisputed that she had been told that the singular photo of the Best Buy receipt had been obtained through a valid search warrant. Detective Walley had no reason to disbelieve that statement. Detective Walley had not gone out of her way even to contact the Washington County Sheriff's Department. To the contrary, Investigator Weatherspoon had conducted the arrest of his own volition on November 13th, and then approximately a week later, Investigator Weatherspoon voluntarily called dispatch at the South Haven Police Department and informed them in brief regarding his findings in that investigation, including that during his investigation he had located several electronic items showing fraudulent purchases made with stolen credit cards. On that day, when Investigator Weatherspoon called on November 18th, he left follow-up contact information requesting that whichever detective or investigator was assigned to the South Haven case follow up and call him. Accordingly, the very next day, Detective Walley did just that, followed up with a call to dispatch that gave a summary of facts that could be helpful in an ongoing investigation. The pleadings solely frame Detective Walley's conduct as passive from that point on. She returns a call during which Investigator Weatherspoon is the one who voluntarily, unpromptedly informs her of the findings of his investigation, informs her that during the course of the investigation, he completed a search warrant on Stephen Lewis's phone and found a Best Buy receipt from South Haven that was for a large sum of money.
What does that mean? He completed a search warrant.
Well, Your Honor, when he said he completed a search warrant.
Does that mean the judge had issued a search warrant, or does it just mean he completed an application, or what? What did he mean by that?
Well, Your Honor, here when it comes to those phrase completing a search warrant, It was undisputed through all the pleadings and through the appellant's opening brief, or the appellee's opening brief, that meant search warrant had been obtained, and completion meant that, say the search warrant said for the days from that on November 18th, he could view the contents of the cell phone.
I'm having a little trouble with our sound system here in following you, but excuse me, go ahead, I'm sorry.
I'm sorry, I can get a little ahead of myself, but on this one, there was no dispute that completion meant.
I'm sorry, what I meant to say was, did Mr. Weathersby say why he was seeking a search warrant?
Well, at that time, he did not say he was seeking a search warrant. He said he had completed it, and that was because he had arrested Stephen Lewis on charges of credit card fraud. And here, Detective Walley was entitled to rely on that representation, but even still, her own conduct did not constitute a search, as the Supreme Court clarified in the 2012 Jones case. Under Katz, an invasion of privacy alone is not a search unless it is done to obtain information, and quote, the obtaining of information is not alone a search unless it is achieved by an invasion of privacy. Here, as framed throughout the complaint and as undisputed throughout the briefing, all that Detective Walley did was follow up. During that follow-up, everything else came voluntarily and unpromptedly from Investigator Weatherspoon. She did not take any intentional actions in order to invade Stephen Lewis's privacy, and it is well established under Supreme Court precedent that the Fourth Amendment concerns only intentional searches and seizures. Here, she did not search Stephen Lewis's cell phone. All of the cases upon which Stephen Lewis relies in this appeal have to do with either manual searches of cell phones or later review of data extractions, which creates a perfect replica of the cell phone, such that the physical block of metal could be returned to the individual, and law enforcement has a replica of it to go back and search, but that is not what happened here. Instead, here, as provided in U.S. versus Runyon, United States versus Jacobson, we have the mere receipt or obtaining of information from another law enforcement agency. That is all Detective Walley did. She did not invade Mr. Lewis's privacy interest. Quite the contrary, here this entire suit can best be described as this quote from Jacobson even, once frustration of the original expectation of privacy occurs, the Fourth Amendment does not prohibit governmental use of the now non-private information. That is all that occurred here. Now, whether Investigator Weatherspoon's actions complied with the confines of the Fourth Amendment, that is not before the court, because under Section 1983, there is no respondent superior. Detective Walley cannot be held vicariously liable for the actions of an outside agency's other officer that were done without her knowledge, and she was informed post-search that a search had occurred pursuant to a warrant. Here, Detective Walley could only be held liable for her own individual intentional conduct. There is absolutely no conduct at hand by Detective Walley that constituted a search, much less any conduct by Detective Walley that constituted a search under clearly established law. The Supreme Court opinion in Anderson versus Creighton is highly instructive. In Anderson, it was too broad and general of a proposition of law for the Eighth Circuit to look towards the general warrant requirement to search a home. Here, the district court looked at a general proposition of a warrant requirement to search a cell phone instant to arrest. However, Detective Walley did not search a cell phone. Detective Walley did not arrest Stephen Lewis on November 19th. Surely, qualified immunity should apply.
Thank you, Ms. Price. You've saved time for rebuttal. Ms. Liu?
Good morning, Your Honors. May it please the Court. Jodie Liu for Plaintiff Appellee Stephen Lewis. Detective Walley cannot obtain reversal without overcoming two significant independent hurdles. First, her newfound appellate theories are plainly forfeit under this Court's decision in Garcia v. Orda.
I'm sorry, can you speak up? I just
Yeah,
can't hear you.
we have a new sound system that we're trying in this courtroom, and I mean, I agree with Judge Richman, it's just not loud enough. But I think we have the volumes turned up. Was yours turned up as loud as? Yeah. Anyway, you're just gonna have to speak loud, more loud. Huh?
Where did you turn it? Let's see. Right there. Turned up.
Okay.
I didn't mean to criticize, I just want to make sure I could understand.
Yeah, why don't you start over and we'll give you your time back. Good. Yeah.
Good morning, and may it please the Court. Jodie Liu for Plaintiff Appellee Stephen Lewis. Detective Walley cannot obtain reversal without overcoming two significant independent hurdles. First, her newfound appellate theories are cleanly forfeit under this Court's decision in Garcia v. Orda. Second, her review of Mr. Lewis's cell phone content in the undisputed absence of a warrant was a search under clearly established law. Starting with forfeiture. In the district court below, Detective Walley's arguments rested on the premise that her review of Mr. Lewis's cell phone content was a search.
You said undisputed absence of a warrant, but the other thing that's undisputed is that Ms. Walley was told that there had been a warrant that had been executed.
It's true that Detective Walley was informed by Investigator Weatherspoon that he had completed a search warrant, but the existence or non-existence of a search warrant does not render a search any less a search. A search is a search regardless of whether there is a search warrant.
So what is the case that comes closest, in your view, to make to constitute clearly established law that under these facts this was a search, not a search by Weatherspoon, but a search by Walley?
The facts of Riley itself clearly establish this. If you look at one of the cell phone searches in that case, the officers barely even opened the individual's phone to look at it. All they saw was A, a photo that was set as the phone's wallpaper, and B, a single phone number on the call's phone log. And that is essentially the same as what Detective Walley saw here.
It's not at all the same, and you know that it's not the same. This is a separate officer who never had access to the phone or to the direct contents of the phone, and further, who was told that a warrant had been executed, and she viewed the data, had been told by another officer that the warrant had been executed. Those are the specific facts here. That's not established at all by the facts of Riley. Did Riley involve a second officer, or did it involve a 1983 suit against an officer who had never touched or had access to the phone? No, it didn't.
So Riley did involve a fact pattern where there were two officers. In one of the searches that gave rise to Riley, Officer A reviewed the contents of an individual's cell phone and then passed the content off to Officer B, who, quote, further examined the contents of the cell phone. There was no question, no doubt in Riley that there were two searches, that each officer had searched the phone. And that is the same is true here. Investigator Weatherspoon reviewed the contents of Mr. Lewis's cell phone and then passed it off to Detective Walley, who further examined the content. And her review of Mr. Lewis's cell phone content was clearly different from Investigator Weatherspoon's review. As to your question regarding whether there was a fact pattern involving an officer informing another officer that a search warrant had been completed, the existence of a search warrant does not make a search any less a search. A search warrant cannot transform a search into not a search. Now, the existence of a search warrant might inform whether a search was lawful or not, but that is a distinct and separate question from whether there was a search. As all agree, here, the Fourth Amendment search question asks whether an individual had a reasonable expectation of privacy in the content being reviewed. So the clearly established inquiry therefore asks whether it is clearly established that Mr. Lewis had a reasonable expectation of privacy in the content reviewed.
Well, what do you do with Ms. Price's reliance on the 2012 Jones case, where she claimed that case establishes that there was no invasion of privacy? That's what she told us. I'm just asking you to give your view of it.
So the Jones case is beyond the reading of this court, but invasion of privacy is only a factor in the search inquiry to the extent that it asks whether an individual's reasonable expectations of privacy were invaded. And so here, as Detective Walley has agreed in her briefing, the question the court must ask is whether there was a reasonable expectation of privacy in the content reviewed. And you can look, for instance, at page 17 of her supplemental reply, where she argues that there was no search because there was no reasonable expectation of privacy in the photos of a receipt that were found pursuant to a valid search warrant. Now, it is undisputed that there was no valid search warrant, indeed no search warrant at all. So what we're left with is the question whether there was a reasonable expectation of privacy in the photo of a receipt. But Detective Walley does not and cannot dispute that the photo of the receipt was Mr. Lewis's cell phone. And under clearly established law, Riley and his progeny make clear that individuals have a reasonable expectation of privacy in their cell phone content, particularly photos on their phone.
Please try to speak up.
Oh, yes.
I'm having a hard time hearing you.
Sorry, I will speak up again. Sorry.
I know it's not your fault, but try to make up for it by speaking up.
Sure. So, again, in Riley, the Supreme Court held that individuals have such a strong protected privacy interest in their cell phone content that it overcomes the search incident to arrest exception to the warrant requirement. In other words, Riley held that reviewing the contents of someone's cell phone since incident to arrest is a search requiring a warrant, notwithstanding the search incident to arrest exception. A fortiori, reviewing someone's cell phone content is a search requiring a warrant when no exception conceivably applies.
So what was Walley supposed to do once she was told by another officer that a search had been executed pursuant to a warrant?
So it is incumbent on law enforcement officers to...
Was that what was told her? I thought she just said she was told it was completed.
That's correct. She had been told that Investigator Weatherspoon informed her that he had, quote, completed a search warrant. And certainly at this stage of the pleadings where the plaintiff is pro se and the court must construe all pleadings in the light most favorable to the plaintiff, it is reasonable the court must assume that the statement Investigator Weatherspoon conveyed to Detective Walley was that he had completed a search warrant application, not obtained a search warrant signed by a judge. And regardless, under...
What's an officer supposed to do? This officer, Walley, had reason to believe that this phone had been searched without a warrant, although there was contrary information either way. But what's an officer supposed to do? Just ignore that, ignore the fact that a violation maybe had occurred and was information being given to her that was in violation of the Constitution? What was Walley supposed to have done? Do you outline that in your complaint?
To make sure that I understand your question, so are you asking what Detective Walley should have done when Investigator Weatherspoon had informed her that he had completed a search warrant and she had reason to believe that there was no search warrant?
I'm sorry, I can't hear you.
To make sure that I understand your question, are you asking what Detective Walley should have done when Investigator Weatherspoon informed her that he had completed a search warrant and she had reason to believe that he had not? Is that your question, Your Honor?
I think that's the question I asked you, but I'm not certain.
Sure, so I'll try to answer it.
I'm having trouble hearing you and following you.
A couple things, Your Honor. So Detective Walley, as a law enforcement officer, it was incumbent on her to make sure that her review of Mr. Lewis's cell phone content was properly authorized. And that, of course, is a question about the lawfulness of her search, not whether she conducted a search, which is the question here. but to address the lawfulness of her search. Under Whiteley v. Warden, it is very clearly established that an officer may not rely on an invalid warrant, indeed a non-existent warrant, to justify warrantless conduct.
How was she supposed to know that it was a non-existent warrant when she was told by another officer that a warrant had been completed?
Detective Walley's knowledge is irrelevant under clearly established law, namely Whiteley v. Warden. In that case, the second police department who acted on the purported warrant obtained by the first department was operating under the correct belief that a warrant had in fact issued. But when the warrant was later found to be invalid, the Supreme Court concluded that the second department's reliance on the first department's actually issued warrant could not justify the second department's warrantless search and warrantless arrest. Furthermore, even if Detective Walley's belief in the existence of a warrant could somehow inform the distinct antecedent question whether her conduct amounted to a search, it would not have been remotely reasonable for a law enforcement officer in Detective Walley's position to blindly rely on investigator Weatherspoon's representation as somehow authorizing her conduct or negating her search. And the long-standing prohibition against general warrants makes this clear. Any warrant issued in the Greenville investigation of automobile burglary could not have authorized officers to probe for any evidence of any general wrongdoing, such as an unrelated credit card offense in another county under the investigative authority of a different department. Now, Detective Walley has also attempted to distinguish her clearly established search from, has attempted to distinguish the conduct from a clearly established search by arguing that she reviewed only one or a few items of cell phone content, not the full range of the cell phone contents. But reviewing some cell phone content is a search regardless how many items of cell phone content are reviewed. And as mentioned, the facts of Riley itself established that, where in one of the searches in that case, the officers reviewed merely 2 items of content, a single photo that was set as the phone's wallpaper, and a single phone number on the phone's call log. And Riley said that was a search. So under Riley itself, it's clear that even when officers review blank items of cell phone content, a single photograph, a single phone number, that is still a search requiring a warrant, absent the application of a recognized exception.
But here, we're here on qualified immunity, not suppression. So didn't your complaint attach, or well, didn't Lewis's complaint attach Walley's report?
It's correct. Mr. Lewis's complaint did attach to Detective Walley's report. Detective Walley's, I'm sorry, Your Honor, what is your question regarding?
And Walley's report said that Weatherspoon had told her that a warrant had been completed, right?
That's correct.
So we're here on qualified immunity, not a motion to suppress. What do you do with that fact in the context of qualified immunity, assuming that it was an illegal search? We're still here on qualified immunity. So let's get past the illegal search piece.
So if the court agrees that there was a search, not even an illegal search, but if the court agrees that there is a search, then it appears to be undisputed that the search was unlawful. And that's because it is undisputed that there was no search warrant in place at the time when Detective Walley searched Mr. Lewis's cell phone contacts. It is undisputed that warrantless searches are per se unreasonable.
But you don't, the complaint does not allege that Walley knew that there was no warrant, does it?
It does not necessarily allege that Detective Walley knew that there was no search warrant.
In fact, the attachment to the complaint says Walley says she thought a warrant had been completed.
Detective Walley's knowledge about a search warrant or not is not a recognized exception to warrantless searches.
We're talking about qualified immunity here. Again, not suppression, qualified immunity.
Correct. Under applying the qualified immunity system, the question is whether it was clearly established that warrantless searches are per se unreasonable absent the application of a recognized exception. That is clearly established. And it is also clearly established that no recognized specific exception to the warrant requirement applies, and Detective Walley's belief in the apparent existence of a search warrant is not a recognized exception under clearly established law, which is the appropriate inquiry under qualified immunity. Detective Walley has also argued that she could not have performed a search because she merely received the material from another officer. But again, the facts of Riley clearly established that a search is still a search.
I take it your position is if there was a search, there's absolute liability. There's no, under qualified immunity, it doesn't matter what she believed or thought, what she knew, what a reasonable officer would have known, what every reasonable officer would have thought. How do you address those prongs of qualified immunity?
So qualified immunity asks whether it is clearly established that the officer's conduct was unlawful, and it is clearly established that warrantless searches are per se unlawful unless a recognized exception applies. There is no knowledge exception to the warrant requirement for searches. And so under qualified immunity, under the clearly established inquiry, Detective Walley's belief in the apparent existence of a search warrant is not adequate.
What about deliberate indifference?
Deliberate indifference, I'm sorry, can you ask, I'm not sure I understand the question.
Well, never mind then.
So to try to answer your question, Detective Walley's deliberate indifference or not is again not relevant to the clearly established inquiry or the qualified immunity inquiry presented to the court. Of course, this court need not reach any of those issues because it is clear that all of Detective Walley's arguments are forfeited. And the district court...
I'm sorry, you're going to have to say that sentence again. I just couldn't hear it. Just repeat your last sentence.
The court need not address any of these issues regarding qualified immunity or the clearly established inquiry because it is clear that Detective Walley's arguments on appeal are all forfeited. In the district court below, her arguments rested on the premise that her review of Mr. Lewis's cell phone content was a search. Now, on appeal, she asks this court to reverse the district court for accepting her undisputed premise. Detective Walley has plainly forfeited that argument. In Garcia v. Orta, the defendant officers asserted one theory of qualified immunity in the district court, and then asserted several new theories of qualified immunity on appeal. This court concluded that the new theories were plainly forfeit. Garcia v. Orta is squarely on point, and Detective Walley has not attempted to distinguish it. In fact, Garcia v. Orta applies with even greater force here, because not only did Detective Walley fail to raise her appellate theories below, but her appellate theories run contrary to the arguments she did raise below at ROA 146 to 147. This court in Garcia v. Orta said that it would not put the district court in error on the basis of arguments never there presented. Here, the court should especially not put the district court in error merely for failing to reject the premise of Detective Walley's own arguments. There is also no basis for potentially excusing forfeiture here for at least two reasons. First, while this court has recognized that it has discretion to excuse forfeiture in some circumstances, it has cautioned against exercising that discretion in a manner that would create the appearance of inconsistency. Here, Garcia v. Orta is a recent decision that is on all fours in all relevant respects. There is no principled basis for reaching a different forfeiture conclusion here than in Garcia v. Orta. Second, this court may only excuse forfeiture if forfeiture would result in a miscarriage of justice. But here the opposite is true. It would be a miscarriage of justice for this court to allow Detective Walley to raise her forfeited arguments on appeal. She was counseled below and had ample opportunity to contest and dispute a search. Instead, her arguments to the district court made clear that she understood her conduct to be a search, and she was merely contesting whether that search was wrongful. So she now asks for two very different bites at the apple, but it would be gravely unfair to put the district court in error merely for failing to reject the understanding that Detective Walley herself put forward to the district court. Now, Detective Walley has also argued that if anyone has forfeited arguments, it is Mr. Lewis, because the district court struck his pro se response brief as untimely, but that is incorrect. Mr. Lewis could not have forfeited his arguments on appeal because all of them are in response to Detective Walley's arguments that she raises for the first time on appeal. Mr. Lewis would have had no reason or opportunity to raise his appellate arguments in the district court below, regardless whether the district court struck his response, pro se response brief. If the court does reach the forfeited issues, I'd like to briefly touch on Mr. Lewis's qualified immunity burden. The district court striking of Mr. Lewis's pro se response brief did not prevent him from carrying his burden to defeat qualified immunity. His burden at the pleading stage was to plead facts that, when construed liberally and in the light most favorable to the plaintiff, demonstrate a violation of clearly established law. Mr. Lewis carried that burden. He pled ample facts demonstrating that Detective Walley reviewed Mr. Lewis's cell phone content in the undisputed absence of a warrant. Mr. Lewis need not have cited, however, particular cases forming clearly established law, because this court must examine whether there is clearly established law, and Detective Walley's own cited cases make that clear. For those reasons, this court should be asked that the court affirm.
Thank you, Ms. Liu. Ms. Price for rebuttal.
Thank you. In this case, it all comes back to qualified immunity. The dispositive question is whether the violative nature of the particular conduct was clearly established at the time. Here, multiple cases clearly demonstrate that the question here, it was not at all established, least of all clearly established. Foremost, there is the United States opinion in Jones from 2012, which is cited throughout the briefing, notably in the appellant's supplemental brief at page 16, that states unambiguously, the obtaining of information is not alone a search unless it is achieved by an invasion of privacy. The critical inquiry under the Fourth Amendment is whether the authorities obtain information with respect to which an individual's expectation of privacy has not already been frustrated. Once frustration of the original expectation of privacy occurs, the Fourth Amendment does not prohibit governmental use of the now non-private information. Accordingly, when Detective Walley merely opened a singular attached file to an email, there was no significant expansion of the search that had been conducted previously by Washington County officials. Not at all sufficient of an expansion to constitute a wholly separate search. To the contrary, this court's decision in United States v. Turner in 2016 puts it best. Once seized, most items do not give rise to a separate Fourth Amendment search inquiry. By the time that the email with the attached photo of the singular Best Buy receipt reached Detective Walley, that had already been seized by the government officials of Washington County without any interaction on her part. The original expectation of privacy in that singular image had been frustrated by the Washington County officials long before Detective Walley ever entered the picture. And when it comes to Riley, Mr. Lewis's reliance upon Riley is explicitly rejected in the Riley opinion itself. Namely, at footnote 1, the Supreme Court wrote, quote, because the United States and California agree that these cases involve searches incident to arrest, these cases do not implicate the question whether the collection or inspection of aggregated digital information amounts to a search under other circumstances. So Mr. Lewis is relying on the Riley decision for precisely that which the Supreme Court discounted and said the opinion could not be used. Moreover, throughout the Riley opinion, distinctions are drawn heavily between the differences in searching a cell phone or, in any other cases cited by Mr. Lewis, a digital replica of a cell phone has to do with the vast amount of information. And the Raleigh court explicitly said that that is different than allowing officers to search a personal item or two in the occasional case. Likewise, the Raleigh court said that it is completely different in looking at a cell phone where the sum of an individual's private life can be reconstructed through thousands of photographs labeled with dates, locations, and descriptions. The same cannot be said of a photograph or two. The Raleigh court has already said that there are notable distinctions between the vast amount of data and information in a cell phone versus an item or two. Here, we are talking about a singular item of evidence that was sent after having been found in a separate search, seized by a separate governmental entity, and sent by email to Detective Walley. Here, there is no clearly established law that could be said to have put any reasonable officer on fair notice that this conduct, as what happened here, was plainly unlawful. In fact, quite the contrary. As this court said in its Morton decision, all Raleigh does is extend the warrant requirement to the cell phone. Mr. Lewis wants this court to create new law. Detective Walley wants this court to apply well-standing precedent and find she is entitled to qualified immunity, reversing the district court's decision. Thank you.
Thank you, Ms. Price. Your case is under